state in this honorable court.
Good morning. Our next case is Bouvier versus et al. Versus Porter et al. I'll note that Justices Earls and Riggs are recused. We'll hear from the appellant.
Mr. Chief Justice, and may it please the court, my name is Craig Schauer. I'll be arguing on behalf of the appellants. I'd like to reserve 5 minutes for rebuttal. This case concerns statements made in election protest forms that were submitted to County Board of Elections and initiated election protest proceedings. The Court of Appeals held that the statements in those forms were absolutely privileged. In other words, the only statements that this case concerns are absolutely privileged statements. That's what the Court of Appeals held, and plaintiffs do not dispute that. Despite those statements being absolutely privileged, the Court of Appeals held that one defendant, Mr. Porter, is entitled to the immunity for having made the statements associated with the absolute privilege. But the remaining defendants, the appellants before you this morning, were not entitled to the immunity for having made the exact same statements. That's not the law in North Carolina. This court held, for instance, in Jarman v. Offutt, that if a statement is absolutely privileged, it, quote, will not support a civil action for defamation. In other words, if a statement is absolutely privileged, nobody can be liable for defamation for having made the statement. Now, this court has repeatedly, time and time again, identified two elements to determine whether or not the absolute privilege applies. The first of which was a statement made in the course of a judicial proceeding. The second element was the statement relevant to that judicial proceeding. While the court has identified those two elements, it's also articulated that the absolute privilege is focused on the setting or the occasion in which the statement occurs. In R.H. Beligny versus the United Steelworkers, this court held that the privilege attaches, quote, by reason of the setting in which the defamatory statement is spoken or published. The privilege belongs to the occasion. In other words, the privilege exists to provide a free flow of information to judicial bodies, of relevant information to judicial bodies. And we're concerned that that information get to the judicial bodies. We're concerned about the relevant information. We're concerned about the statement and where it occurs. We're not concerned who made it or how it got there. Now, the Court of Appeals departed from this court's precedents and identified a third element. It created what I call a participants requirement. The participants requirement is problematic for at least 5 reasons. Quickly, it's unprecedented, it's undefined, it's unnecessary, it's actually based on a legal fiction, and it's going to result in unwanted consequences. It's unprecedented because this court has never articulated a third element. And this court has certainly never held that a privilege applies to a statement, but a defendant who made the statement is not entitled to that privilege because they didn't sufficiently participate in a proceeding. The absence.
So imagine a scenario where someone goes in to file an election protest that says, you know, my neighbor voted, you told me he voted twice. Also, he's having an affair and cheating on his wife. You would agree with me that the statement that got stuck in there about the affair would not be privileged from a defamation claim. Would you agree with that?
I would agree with you because it doesn't satisfy the second element, Your Honor.
And I understand the theory to be, well, if you're someone who is not in a position that you could be the filer and bring it to the judicial or quasi-judicial proceeding, then your statements can't ever fall into that category because you would never be able to invoke the privilege yourself anyway. And that's part of the theory here is that's how you can draw a line between the people for whom you can pursue the claim and those who have the privilege. What's your response to that?
Well, a few responses. First off, I think that distinction is actually a legal fiction because it rests on the argument that a defendant can publish a statement for purposes of defamation liability, but not be the publisher for purposes of the immunity that attaches to the statement. In other words, they own the statement enough to be liable, but they disown the statement when it comes to the immunity associated with the statement. I think somebody either makes the statement or they don't. You can't have it both ways. It's a legal fiction to say that it's both. Second, I'd note that the absolute privilege applies in multiple contexts, not just formal trial proceedings where we have civil rules of procedure, rules of evidence, defined roles, experienced participants. It applies in informal contexts such as quasi-judicial proceedings like an election protest proceeding, where information doesn't come in through the normal channels that you see in a trial court proceeding. So for instance, information can come in via email. sent in by an individual on behalf of another individual. In other words, there can be multiple speakers for a single statement, which is unique to more informal proceedings and you don't find in trial court proceedings. And so applying, trying to create a distinction prevents people from being entitled to the privilege in those informal proceedings where there could potentially be multiple speakers for a single statement. Not only, going back to the precedent, it's unprecedented. Not only has this court never recognized those elements, but the Court of Appeals has never done so, recognized a third element until this case. Notably, the plaintiffs, or my friends on the other side, they haven't been able to identify any court in any jurisdiction that's recognized that the element of participation as being a third component of the absolute privilege. And notably, this court, I believe on at least 2 occasions, has identified that the privilege applies in situations where it's arguable that the individual wasn't actually a participant. The first case is Nissen v. Kramer. It involved a lawsuit with a company. At trial, the company was represented by counsel, and they also had a company representative there. The plaintiff in the case took the stand and called the company representative, accused him of taking a bribe. The company representative jumped up and said, "You're a liar." The court, in analyzing that situation, made 2 interesting points. First, it made the point that the company representative wasn't entitled to speak at that point. The company was represented by counsel. In other words, that was not authorized participation. The court actually said they could be censured for what took place there. So in other words, to the extent they participated, it was improper participation. But the court didn't dwell on that point. Instead, they focused on the 2 elements of absolute privilege. It clearly appeared in the course of a judicial proceeding, and it was relevant to the proceeding because it was talking about somebody on the stand and their credibility, so therefore the privilege applied. Another case is Jarman v. Offen. In that case, a husband initialed a civil commitment proceeding by going to a clerk of court. As part of that process, you have to get 2 affidavits from doctors who are willing to verify that the individual you want to commit has issues that would justify commitment against their will. The husband secured an affidavit from a doctor. The doctor completed the affidavit, but never actually submitted it to the clerk. In other words, it never became a part of the actual proceeding before the clerk. Instead, it was found behind a file cabinet in the husband's barber shop. Well, the civil commitment proceeding was for the husband's wife, and so the husband found the affidavit and sued the doctor for defamation. The court held that the absolute privilege applied because the statement, even though it didn't make it to the clerk, was clearly part of the proceeding that was initiated by opening the civil commitment proceeding. And it was relevant proceeding because that's what doctors speak to, the mental health of the individuals who might be committed. But notably, that doctor didn't actually participate in the proceeding. His testimony never actually made it into the proceeding. It stayed dormant behind a file cabinet for years. Yet the court didn't dwell on whether or not he was a participant or not. It focused on the 2 elements, and it applied it.
Yeah, these cases are helpful for you, but then when you look at the tests that we articulate, it seems to sometimes be limited. So for example, we'll say things like out-of-court statements by a party to the proceeding and that sort of thing. And the examples that you're describing and this case involve a number of participants who weren't in any way parties to the election protest filing. So do you think that's just sort of the word party there was just the courts? We sometimes use that and we don't mean it in its very technical sense, or what's going on here?
Well, I think if you look at the body of law on absolute privilege, the privilege most often appears in the context of trial court proceedings, right? Which we would expect, and therefore you have defined roles such as a party, counselor, and witness. And so it would be natural that you're talking about whether or not somebody was a party, a counselor, or witness, because that's how information comes to the decision makers in trial court proceedings. Quasi-judicial proceedings are very different, right? There's often, if there are procedural rules, they're sparse, there may not be non-existent. To the extent the rules of evidence are there, the adjudicators might not be following them. Oftentimes the adjudicators are not lawyers. They may not be even versed in the law very well that's applicable to the proceeding. And so it's a far more informal proceeding where you would have somebody who doesn't fall into one of those predefined buckets that are clearly available in the trial court proceeding, but would nonetheless be a participant because they're providing information. And I think this case is actually a great example of that. Here, Ms. Clark, for instance, submitted an affidavit. Submitted an election protest. It was received by the board. It triggered the board's proceedings. Then she was contacted by a representative of the board, one of the officials, and said, do you have any additional information that you'd like to provide in support of this election protest? And she submitted additional information that showed that the individual in the protest was registered to vote in another state. And so there, you really have a difficult time putting Ms. Clark in any of the buckets that you would see in a traditional proceeding. She wasn't counsel, she wasn't a party, she wasn't a witness, but she was clearly a participant. In fact, the decision makers reached out to her and solicited additional information beyond the initial contact of submitting the statement, and relied on that information in making a decision. And so I think I think what we see in the cases, and even in the restatement, is a reflection that the absolute privilege most often appears in those formal settings. And so using the term participant and looking at those roles makes a lot of sense in those settings, but because the absolute privilege appears in more informal settings, the court should not be confined to those predetermined roles in determining whether or not the privilege applies, which is why the two elements work well. Notably, the absolute privilege, it doesn't need a third element because there's an element of participation implicit in the two existing elements. If somebody makes a statement in a judicial proceeding, they necessarily participate in the proceeding, especially if it's relevant. So therefore, you don't need to look at whether or not they engaged in additional conduct beyond making the statement in a proceeding to determine whether or not the absolute privilege applies.
Can you help me understand the intersection between the right to petition the government, as we set out in the Humphrey Land Investment Company, and an absolute immunity or absolute privilege defense that's being discussed here?
So, Your Honor, I don't have that provision in front of me, but my understanding is that provision refers to the General Assembly, so I'm not sure it would create a right, a constitutional right that would be invoked in this case. Although I will note that the election protest procedure is the forerunner to bringing certain decisions to the General Assembly. For instance, if you were challenging the election of, I believe, the governor.
No, what I'm talking about in that particular case was the right to petition the government.
Yes, Your Honor.
And that was in a rezoning setting. So it seemed to me quasi-judicial setting. Nobody inquired where the corporate official got his information, how many people participated in that information. But at the end of the day, we made it clear that a person has a fundamental right to petition the government under these types of proceedings. And it seems to me that you're weighing the public policy with regard to a protection of an individual or protection of the individual, but the more important aspect of having a process where parties can come before the quasi-judicial official, make their presentation, and we allow the process itself to determine the veracity of what's presented.
Your Honor, that's a great point. So in other words, I'm not sure that the genesis of the absolute privilege is in the Constitution, but I think the motivation for the constitutional provision and the absolute privilege is the same. There are certain settings in which society has made a determination that we want information to flow to the government because the interest in the government having that information and people being able to speak freely outweighs the potential harm that information may have to an individual. This court has recognized that that's the motivation behind the absolute privilege, and I believe that's the same motivation behind that constitutional privilege.
So I don't mean really to push you ahead in your argument, but I know you also have a principal agent argument. But as I was thinking about this case, it seemed to me that if we accept your theory that it's really the setting in which the statement is made that controls, that we wouldn't have to reach that issue. Would you agree with that, or am I misunderstanding?
Correct. So I believe if I could suggest a way that the court would write an opinion in our favor, it would be focused on the two elements being satisfied here, and it would not reach the point of an agency issue. Even though I do believe agency is an alternative doctrine, I think the fact that the two elements are satisfied means the privilege applies to the statements. Nobody can be liable. The agency theory is an alternative theory and another ground for upholding this case, should the court, for instance, adopt a participant's requirement, which I'd encourage it not to.
So one of the things that the other side says is that if we were to apply the absolute privilege in this context, that it would mean, for example, that if the defendants engaged in their activities, if their activities amounted to the unauthorized practice of law, that they'd be immune from any kind of consequences for that, and not just immune to the defamation claim. What's your What's your response to that?
So, Your Honor, I don't believe the defendants engaged in the unauthorized practice of law. Second, to the extent they did, I don't think that's a factor in whether or not the absolute privilege should apply. But to the extent they did, there are other means of recourse for that. There's a civil cause of action under Chapter 84 that an individual can file against someone who engages in the unauthorized practice of law if it harms you. The state bar could take action, and I believe there could be criminal prosecution by the district attorney. So to the extent that conduct occurred here and needed to be remedied, the solution would be other means other than modifying the absolute privilege.
So we're looking at immunity to tort claims here, specifically defamation, and not at those other things.
Correct. The last caution about adopting a participant's privilege that I'd like to talk about is unwanted consequences. My friends on the other side are advocating for a rule that if someone ghost writes a pleading, in other words, they help someone draft it and it gets filed, that they don't appear in the proceeding, that they could be liable for defamation. The North Carolina Bar has recognized that attorneys can ghostwrite pleadings. They didn't use that language, but they issued a formal opinion, and it was actually issued to legal aid upon their request, saying that attorneys can help individuals or pro se parties draft pleadings and submit them without making an appearance. And I think that's really important, and that opinion is really important, in part because of who requested it. Legal aid right now, should the Court of Appeals opinion stand, is faced with two unattractive choices. The first of which is if an indigent client comes to them and needs help in a pleading, they have the option of committing to help the individual draft the pleading, but also making an appearance for that individual and staying with them through the course of a proceeding in order to be entitled to the absolute privilege. The other option is that they can ghostwrite a pleading, help them file it, not make an appearance, but be exposed to defamation liability. I imagine legal aid will choose neither of those options, and they'll simply stop offering that service to individuals who need it, and they'll stop helping individuals write complaints that could be filed without them appearing before them. And I don't think that's a consequence that anybody in this room wants. If there are no further questions, I'd like to reserve the remainder of my time for rebuttal.
Thank you, counsel. We'll hear from the appellee.
Mr. Chief Justice, and may it please the court, I'm Press Millen from the Womble Bond Firm. I represent the plaintiff appellees in this matter, who are the two surviving Guilford County voters and one Brunswick County voter who were falsely accused by the defendants of voting in North Carolina and in another state in what defendants characterized as, quote, a clear violation of North Carolina and federal election law. Here with our colleague and co-counsel, Mr. Jeff Loperfido. This court has consistently made it clear that the general rule in North Carolina, as the Court of Appeals put it in the 2020 Topping case, is that immunities from suit and assertions of privilege are strictly construed in North Carolina. Under North Carolina law, in other words, a person is not simply granted an immunity willy-nilly, but has to earn that immunity, in a sense, by fulfilling some actual role in a judicial or quasi-judicial proceeding as a party, as an attorney, a witness, or a judge.
What did the doctor in Jarman, with the affidavit that was never filed, what role in the proceeding did that doctor play?
That doctor was a witness, and this court and the Court of Appeals has made it clear that witnesses and potential witnesses in the context of those who are submitting affidavits are covered by the privilege.
So if the doctor in that case had written a letter to the editor in the newspaper, said a bunch of defamatory things about the wife in that case, that would, so
No.
there also must be some connection between the reason that he prepared the affidavit and the proceeding. Would you agree with that?
There has to be a proceeding in which one can be a witness or a potential witness.
So imagine a situation where you come back from having a surgery and things just went terrible. You're, something's wrong, the surgery didn't work, you're worse off than before, and so you go and you talk to a doctor and you say, you get essentially a second opinion and say, did something, did these doctors that did my surgery mess up because I'm off sick and, and the doctor says, yes, I think the doctor that did your surgery did not comply with the standard of care. You have a claim here. And then you go and you, based on that information, you file your claim. Is it your position that, just like your clients, if it turns out that you lose the case, so you falsely accuse that doctor of not adhering to the standard of care, that the doctor who had been sued can sue the other doctor? And if not, what's the difference between that scenario and this case?
I don't believe so, Your Honor, because in that case, the consultation is about the prospective lawsuit. The consultation is with a person who is or could be a potential witness. In fact, that's almost the exact factual situation of the Court of Appeals decision in Rickenbacker versus Coffey, where it happened to be a dentist in that case, but it was essentially the same principle, although the approach was made by the lawyer. So there is this penumbral area that certainly covers people, but they're always people with status. And what I would say is—
What do you mean status?
They have a status in the context of a proceeding. In other words—
But this doctor that I'm talking about is just some friend of the plaintiff who never appears in the case, isn't a witness in the case or anything, just assisted them in assessing whether or not they might have a claim and should just consult a lawyer.
I think that would fall into the potential witness area as—
Well, if it's that minimum, the bar, then how can the participants who are the appellants here not have been doing a similar thing? Because they were certainly involved in the process that we describe as the occasion of preparing the election protest, providing the information, doing everything that my doctor is doing in the hypothetical. So, well, how are we going to draw that line?
I think the difference is they disclaimed, they explicitly disclaimed in this case that they were participating as counsel or that they had an attorney-client relationship with the protesters who submitted the protest.
But the doctor in my hypothetical is not a lawyer and is not suggesting there's any patient privilege or any kind of relationship. It's just someone who's an expert providing information about this potential lawsuit. So I'm just not seeing how you can win this case without completely upending all of the case law we have in the Court of Appeals and the Supreme Court about what the occasion is and how it can include people whose communications with the person who's actually the filer are there solely to prepare for the filing in the judicial proceeding or here quasi-judicial. And I don't think you have any evidence that the appellants that are here today publish this information in any other context than in assisting the filers. Am I right about that?
That's correct. But what I would say is that for at least 37 years, the courts in this state have consistently followed the formulation of the restatement. In the restatement in sections 586, 587, 588 talks about the privilege as applied to a party, the privilege as applied to a lawyer, the privilege as applied to a witness. In other words, despite what my friend has suggested—
Then using that, my doctor in my hypothetical just isn't entitled to the privilege. I'm having trouble seeing how you can get from that narrow view to what we know is the case, which is it is actually in our case law much broader, and how we can do that without it encompassing the appellants here.
Because I think in that case you are talking about a potential witness. In this case, you're not talking about potential lawyers. You're talking about people who happen to be out-of-state lawyers who are explicitly disclaiming that status in order to do what they did.
So would you still have the same argument if these individuals were not lawyers? They just happened to be people who were familiar with the various databases, statisticians or whatever, and they still provided the same information. Would you still be making the same argument?
I think I would be making the same argument if the context were the same. In other words, if they were the ones who were prompting the protests, providing information to protesters in the form of protests, mind, that had, 5 different false statements. In addition, 4 in addition to the false statement about double voting.
So you just said the key thing to me that is my issue with this case, because that to me is your strongest argument, would be one that says these appellants should have known that this information was false, and they induced other people to publish this information in a very high-profile way by making the election protests that caused great harm. And there are tort claims that cover that kind of reckless inducement. But it's not the claim that you filed in the complaint in this case. It's not a defamation claim. It's a tort claim for inducing someone else to engage in these acts, and which would be subject to an absolute privilege for defamation. So it seems to me like this case has the wrong claims in it, because the defamation claim under our case law is absolutely privileged.
I don't think that's correct. I think that our courts have made it clear that there needs to be participation in order for this to apply, because if there's no participation, then there's no appropriate corresponding safeguard that's in place to stop.
And Counselor, you do rely, and you mentioned the restatement already, and I think that that's a cornerstone of the argument that you're making. Who promulgates the restatement of torts? Where does it come from?
So the restatement of torts is from the American Law Institute, and what it attempts to do is to summarize the common law, essentially majority positions of the common law throughout the United States. The restatement has been followed by the Court of Appeals since 1987.
Are we to follow the Court of Appeals? How does that work for us?
I wouldn't say that, no, certainly the Court of Appeals is not binding on this court, nor is the restatement binding on this court, but I do think it applies.
Sir, do you have any, so you are placing the cornerstone of your argument on the Court of Appeals and a group of lawyers somewhere else. Are you trying to tell us that we should look at that rather than the precedents of this state and perhaps the United States Supreme Court?
I certainly would say the United States Supreme Court and the precedents of this court would be the appropriate ones to follow, but it's very interesting. This court, by my calculation, has not considered an absolute immunity case in a defamation setting in 67 years. Not
That gives us an opportunity today.
That's true. I do think that the restatement provides guidance to this court, and good guidance to this court. I would also note that in the briefing below in the Court of Appeals, that the Defendant Defense Fund characterized the restatement as a, quote, fair summarization of the common law of the state of North Carolina and the other 48 states' majority rules. So they were agreeing with the restatement. As I said, the restatement, again, has not come before this court in this particular setting, but has come before the Court of Appeals, and very consistently, starting in 1987 in the Harris versus NCNB case, in the Hope case in 1998, the Harmon case in 2004, Jones versus Coward, 2008, McManaway, topping unanimous decision of the Court of Appeals in 2020, and then this case in 2021, asserting the participation and participating requirement and citing to the restatement as guidance.
I'm glad you draw us back to the participating requirement, because I'm struggling with the common definition of what participating is. I have trouble understanding how one can publish if one is not participating.
Because I think one can do what was done in this case, which is someone who has no status, who is not admitted in North Carolina as a lawyer, who does not seek to become admitted pro hoc, is not a member of the bar here, uses someone else who does have status, the status of a party, and party here under the statute in Chapter 163 could be one of two persons, either the candidate himself, and the candidate himself determined not to involve himself as a party in these protests, or an eligible voter in the particular election, and that was these individuals in the counties, to use that person as a stalking horse, essentially a cat's paw, to do something that the person without status, these defendants, could not do. And it happens to be something that requires them to falsely accuse our clients of a felony,
But again,
which is defamation.
I understand what you're saying, but you just brought the wrong claims if that's your theory, because the reality is our law has said the occasion will encompass people beyond just the person who's capable of, for example, filing a lawsuit. It will cover the doctor who's a consultant providing you with input about how to pursue your case, and in doing so, may say a bunch of things about how bad the defendant is and why you've got a good case, but you can't sue that person if it turns out, that you lose the case and that they were wrong. That the ideas that will make the privilege cover everything that's happening in the judicial proceeding, including all of the sort of periphery, I'm working on the case, out of court statements. And that's what I just can't get past here, is everything you're describing is a tort claim, just not the one that you filed.
Your Honor, I would respectfully disagree. And in part, what I would say is that this privileged occasion language that the defendants rely upon comes from the 1967 case, R.H. Bellini. He mentioned it, my friend mentioned it earlier. That case, in our view, is far too thin a thread on which to claim absolute privilege for a number of reasons. First, the case itself did not concern absolute privilege, only a qualified privilege, and the court actually found in that case that no absolute privilege existed. Second, the case did not concern any sort of judicial or quasi-judicial proceeding. Rather, it arose in the context of a claimed libel in a union organizing effort. Third, the case, Bellini, did not concern attorneys or clients or agency.
I'm sorry to keep interrupting you, but you've raised that a number of times too, so help me understand why, getting to the Chief Justice's question, just if they weren't lawyers in this case, how would anything be different? And if the answer is it wouldn't, in your view, why does it matter? Why do you keep bringing up the fact that they were maybe practicing law here and they hadn't been admitted and so on and so forth? Why does any of that matter?
I think it matters. I think it matters for two reasons. Because the way this privilege does not exist to permit libel. The privilege exists to permit the fair and efficient administration of justice. That's what it's here for. And so we have a situation where, and I agree, it doesn't matter whether it's lawyers or non-lawyers if they're engaging in the particular conduct here. But there essentially needs to be something, a safeguard that exists that somehow constrains the behavior of the persons to whom the privilege is applied. Now, this court, again, has not specifically dealt with this circumstance. It is mentioned in the restatement 586 in comment A, but there's a very good public policy reason behind that. We did cite, to your honors, cases from the D.C. District Court, the D.C. Court of Appeals, Washington State Appellate Court that all essentially say, of course you have to be a participant as counsel in this case, because if you're not a participant, there are no safeguards against abuse of the privilege. And so, in other words, if a lawyer, let's just take the example of a lawyer, but it could apply just as easily, Justice Dietz, to a non-lawyer doing the same thing. If a lawyer is not participating in counsel, but hiding behind a non-client stalking horse, as defendants did here, there's no judicial sanction that's available against that attorney. There's no potential for bar discipline or for violating ethical rules. And the same holds true for other types of participants.
Why do you say that?
Because for parties, for example.
But why would the absolute privilege prevent you from being disciplined for an ethical violation or anything else?
Because otherwise, if the absolute immunity is left floating in the air for anyone to take advantage of, irrespective of status, irrespective of participation, irrespective of the manner in which they engage in whatever is the defamatory conduct, what you're doing is you're freeing up the prospect, and I think a very dangerous public policy prospect, for people, essentially to do, what has been done here, which is, to potentially sit back in another state, whether it's Virginia or California, North Carolina, get stalking horses to file, could be an election protest, it could be some other thing in a judicial proceeding or a quasi-judicial proceeding, people with no knowledge, who simply, are gulled into filing something like this.
I'd like to, sorry
Yes, sir.
to interrupt you, but you have several times brought up policy considerations. It seems to me that the whole reason we would apply the immunity in the election protest context would be so that people won't be intimidated into not making protests when there's a basis to do so. And if you're going to make that kind of protest, it seems to me that one of the things in the absence of an immunity that you would be most concerned about would be that if you happen to be wrong, you might find yourself sued for defamation. In other words, it seems to me that defamation would be one of the core things that the defamation claim would be one of the core things that the immunity would be intended to prevent. And we'd want to do that because if we want people to come forward, if they have information about unlawful voting practices, so that our elections will be valid.
And I agree with what you're saying, Justice Allen, but up to a point. And here's the point where I think, get off the train from what you're saying. Yes, on the one hand, if there is a party who files a protest under the formulation that the Court of Appeals unanimously came to here, that party, Mr. Porter in this particular case, is free to engage in that conduct. What they ought not to be free to do, however, is a non-party, non-witness, non-lawyer, non-anything person essentially create, and I don't think this is what we want to encourage, the creation in blank of election protests which contain entirely false statements, and which are known to contain entirely false statements, and which are admitted to be false statements. It's false statement number one, that these defendants voted in 2 states, and then the amplifying false statements that these listed protesters, Mr. Agavino and Mr. Porter, were witnesses to the alleged misconduct. That's not true. Second, that the allegations are made on a review of the public records by those witnesses who signed the protest. That's not true. Third, that the allegations were sufficient to affect or cast doubt on the election itself. Not true. And fourth, that the listed protesters had read and reviewed the North Carolina law of elections, protests, and the regulations. Again, Mr. Porter, as a party, is free to make that, even though all of those statements are false.
But he has to have some information from somewhere, right?
The only information he had was that he was told by these defendants that he should sign this. In fact, he didn't even sign it. It was signed on his behalf.
So, but there's information. So is it your position that anybody that works for one of the national groups that has a database that does the comparison between who voted on election day or who voted early versus who voted in another state, that anybody associated with that process is liable under your theory?
No.
Why?
Because if that person is...
Which person?
If the person that you are describing, which is the person who is the data person, for example, is a witness or a potential witness in the protest, then that person would be immune in our circumstances.
Well,
but that's not this case.
It is this case because those individuals who are the middle people, the ones who took the data from the source and communicated it to the people who would actually file the protest, they are potential witnesses. Why is it that these individuals were named in the protest? Well, I got the information from the middle people. Middle people, where'd you get it from? Well, we got it from the source. They're all potential witnesses under any definition of that term, aren't they?
I don't think so.
Why?
Because I think that these lawyers who were acting on behalf of their true principal, The
Now,
defense.
wait, now you've gone back to lawyers.
Well, these defendants, these out-of-state lawyers who were acting on behalf of their true principal, which was the defense fund here, they're not witnesses. The
What do you
RNC.
mean they're not witnesses? They have, did you, I don't know if you deposed them, I assume you did. If you did, they are witnesses. And they're witnesses because they're the conduit from the information from the original source, ultimately to the voter.
I would agree that they are witnesses in the defamation case, and they were, but they were not witnesses in the protest case.
Hold on, let me ask you about that. So suppose that the allegations were true. Suppose one of the people for whom an election protest was filed had double voted in another state as well. So our election board says, we're trying to look into this, but can you put us in contact with, how do you know this information? In which case the filer would say, these empiricists, these data people have explained it to me. Wouldn't the election board investigators be reaching out and trying to get that information?
I think they potentially
So
would.
how is that any different than the doctor who's consulting who might be a witness in the Med-Mal case?
Well, mind you, on the record here, the people whose data was used to make the accusations did not know that the data was going to be used for that purpose, and specifically told these defendants, if you're going to use the data for that, it needs to be checked further, which was never done. So that, and just on the factual basis,
But
that's
all of
quite
the
different.
things you're describing, those could be relevant to a tort claim. I mean, if you intentionally, recklessly, without providing the information, induce someone else to engage in some kind of intentional tort that causes great harm to someone else, I mean, you can be liable. It's just you didn't, instead of bringing those claims, you've brought a defamation claim, sort of a pass-through defamation claim that's going to cause great harm if we adopted your theory. In all other kinds of settings where there's out-of-court statements related to a judicial or quasi-judicial proceeding, and I'm just struggling to figure out why you want us to just blow up this very settled protection in this scenario when there's other claims that could be pursued if you believe you're right about it.
I don't think there are other claims. I think the claim is a reputational damage claim, which is a defamation claim. And I don't think there is a generic intentional tort claim for intention to cause someone else to defame. I think that, or if there is, that's essentially what's being pled here. But I would say, again, I don't think that extending the absolute immunity to these defendants is in any way consistent with what this court has done in the past. And to put it on the thread of the Bellini case, again, concerning a union campaign, it has no guidance with respect to absolute immunity. And, they use it as a mantra, this privileged occasion. It's dicta because in Bellini, there was no absolute immunity was found, quite the contrary. And and that particular mantra that they use from Bellini has never been cited by this court in any other case. So simply put, I think Bellini and the other qualified privilege cases that they cite, which would be Ponder and Ramsey from 1891, I simply don't think that they have any applicability here. Now, with respect to the other cases.
Counsel, I apologize.
Yes, sir.
I'm struggling with the question that Justice Dietz asked regarding double voting and an out-of-state investigator from another board of election, another governmental entity, private group, and says, look, I've looked at this information, and it does appear that John Smith double voted, and I've relayed that investigator relays that information. How is that different from this situation?
I think the difference is, in the normal course, what we would expect is that the information would go to an attorney, and that attorney would then be participating in the creation of the protest, appropriately so. That attorney would have safeguards around him by virtue of his status as an attorney and by virtue of his participation in the particular proceeding. That's not what happened here.
Yeah,
What
I
happened
think
here
part
was
of that is I
extraordinarily
think you've gotten a little too close to the case, because I don't see how we could possibly try to frame the law around the idea that everyone's going to be able to find an election lawyer. I mean, the purpose of this privilege is that ordinary citizens who want to file an election protest will be entitled to the same absolute privilege as a lawyer with a fancy graduate degree. You
And
go
they
in and
are.
you file it, and so we can't structure a system where we assume that there's going to be a lawyer involved. We have to look at a scenario where you've just got ordinary people and they're talking, they're at the pool hall and they're talking about the fact they think there might have been voter fraud, and one of them goes and files the complaint. The whole occasion will be protected, all of the discussion that led up to that filing. That's what the privilege is intended to protect.
Certainly the party would be protected. And certainly to the extent that the person's providing the information, had information, and were witnesses or potential witnesses in that protest.
But what if it was just a neighborhood meeting where they're concerned about it, they discuss it, and choose someone to go file it? You're saying everyone can be sued for defamation except the one person who actually filed the complaint.
That seems like I understand the hypothetical, but it seems like number one, relatively far-fetched in terms of how these things work in the context of the timing involved in elections protest. And second, not at all what happened here. What this court will be doing, if this court reverses the Court of Appeals, is this court will be creating a group, a creature, who is entirely able to act with impunity in the context of judicial and quasi-judicial proceedings without being lawyers, witnesses, or parties, who has no safeguards that apply to them in any respect.
Well, if they practice law, if it was the unauthorized practice of law, they can be charged. I mean, it's a crime, right? And just any other improper conduct that happens during this process, none of that's protected. The only thing the privilege protects is your defamation claim, the one claim that you brought in this case. But any other bad behavior, any other tort, the privilege wouldn't apply to that, right? So there's so much out there that can prevent the kind of harms you're describing.
The idea, I mean, certainly the unauthorized practice of law would provide no remedy for my clients. In addition to that, as this court held in Ray Smith, if you've got out-of-state attorneys like these folks here who are not admitted in North Carolina, like these folks here, who take no steps to become admitted pro hoc, then this court, all of our courts, none of our institutions have any corresponding safeguards on which to hem them in, and they will be free to engage in this conduct. And I think that is bad public policy. I don't think it's consistent with at least 37 years of learning from the Court of Appeals. This court has never dealt with it. We'd ask that it be affirmed.
Thank you, counsel.
Thank you.
Rebuttal?
Thank you, Chief Justice. Just a few points. The restatement has been cited by the Court of Appeals in the past few decades. In each of those instances, as far as I can tell, it's been in the context of a trial court proceeding. And the court based its decision on the two elements and then looked to the restatement to confirm that the application of those two elements in this context was not unprecedented. It was recognized by the restatement. This is a new factual situation. It's not a trial court proceeding. Second, we do reference Beligny. It was a case about qualified privilege, although it talked about absolute privilege, and it talked about the occasion. We also cite three other decisions by this court, Scheffler v. Gooding, the Jarman decision, and Ponder v. Cobb, that talks about the privilege belonging to the occasion or the setting. Beligny was just a convenient expression of that we cited. More importantly, this court has always relied on two elements. Is it in a proceeding, and is it relevant to proceeding? The list of cases is long. I'm not going to read them for you. They're in our briefs. That's the test that the court has always recognized. That's the test that the Court of Appeals applied to determine that the statements are privileged, but then it took a sharp turn and withheld the privilege from certain defendants in this case because of a new element that we asked this court not recognize, that they didn't sufficiently participate. If there are no further questions, I'd ask that the court reverse the decision below with respect to the appellants. Thank you.
Thank you, counsel. Thank you, everyone. Mr. Clerk.